Here we are at another episode or the second part of a two-part series of Unraveling Intellectual Property with Michael Stein, where we talked about in the first episode, and we'll continue in this episode, regarding things that a startup, a small company, a medium-sized company needs to consider, take into account when they are starting a business or during the life of the business. Again, we've got Marc Whipple here to continue our discussion. Welcome back, Marc.
Thank you.
My first question in this second part is, when does an entity consider to pursue patents or pursue copyrights or trademarks?
Well, patents is an easy one to answer as soon as possible. Patents have a term on the order of 20 years. It can be a little weird, but think that it's going to be good for 20 years. So unless you think you're not even going to start practicing your invention for 5 or 10 years, you should file your patent as quickly as possible. And even then you should, because if somebody else comes up with it and beats you to the patent office, you're out of luck, or just even discloses it. So
Or
patents are
discloses or sells, right?
or sells. Yeah,
Okay.
absolutely. So you want to do the patent as fast as you can. Copyrights have a term on the order of decades. So again, as soon as you can. If you're doing computer code, then that answer gets a little bit weird. But if you're doing that, then you want to talk to an experienced tech attorney who's familiar with what you do to copyright computer programming. Trademarks, that's an interesting one. You may be familiar with the fact that there are people who do nothing but go over the trademark application files for every trademark office in the world, looking to see if Apple or Microsoft or somebody else has filed any new trademark applications, because you are required to describe the goods that you are going to use the mark with. So if they file a trademark before they announce something that they're going to sell, people have in fact caught them selling new things before they meant to announce them. That's usually not a problem for most small and mid-sized businesses, but it can be. Your trademark attorney, somebody at Stein, will know that and can discuss it with you. So you want to file that when you're getting ready to put it into the marketplace. It's not as big a rush. You want to give yourself some time, because it can take 6 to 8 to even 12 months or more, depending, for a trademark registration to go through. But the nice thing is you don't have to have the registration completed to use the mark. And again, that's something you discuss with your trademark attorney. So trademarks, the trademark for the business, if you're going to trademark the name, I do that as soon as possible, because if there are any problems, you want to know about it as soon as possible. As far as product lines, during the design of the product line, you want to talk to your marketing and salespeople, find out what they think of the marks. There's a lot more to consider with those. So trademarks, not as big a rush. Patents and copyrights, usually as soon as possible.
But with patents, I mean, I know there's no common law rights. Trademarks is different, right? You get common law rights based on usage, and then so it's not quite as critical to file immediately because you do get some rights just from the use, correct?
Exactly right. As noted, that's called a common law usage. Basically, you're not allowed to use a trademark that would confuse the public, the people in the market you're trying to sell your goods and services to.
I think
So,
not necessarily confused, but likely to confuse.
a likelihood of confusion.
Yeah.
You're not allowed to create a likelihood of confusion. Thank you. So if you go into the market and you start using your mark, maybe your registration is pending, maybe you decided not to register that particular mark for whatever reason, but people start associating it with your goods and services, with your beer, your soda pop, your tape measures, whatever. And then somebody else comes along and tries to ride on your coattails. Even if you haven't registered it or gotten the registration approved, you still have legal rights. They can't do that. It's not so much that they're hurting you as that they're hurting the public, and we don't allow that. That's what trademarks are for.
And is there reasons to not pursue patent or copyright or trademark? Or, you've talked about the advantages. Are there any disadvantages to consider, or trade secrets? How does that come into play?
Absolutely. Until you disclose it, anything confidential that can materially affect the progress of your business can be considered a trade secret. There is a federal trade secret law, but it's very broad. Most trade secrets are going to be enforced under state laws. So you want somebody who's familiar with that. Illinois, for example, has a really good trade secret law. I know New York does. I believe California's is pretty good. Anyway, some states are better than others. Big commercial states will usually have better trade secret laws. So you want to keep it a secret unless you have a reason not to, because then it's a trade secret. If somebody who works for you walks off with it, and it could be as simple as your customer list. Your customer list is a trade secret if you don't reveal it to the public, and they're very valuable. I've been involved in very expensive litigation just over customer lists because a salesperson took his Rolodex with him, so to speak, although, of course, nobody uses those anymore. But why would you not want to file one? Like I said, for starters, with trademarks, you have to describe what you're going to sell. So if you don't want to tell the public, because trademark registrations are public, as are copyright registrations. Patents applications are not, sort of, and I'll touch on that very briefly in just a second. But you file that trademark application, and in 2 weeks or so, everybody in the world can tell that you've registered your mark and roughly what kind of goods you're going to sell with it. You may not want your competitors to know that yet, so you may want to hold off on filing it. I have a terrible story about that one, which I won't share, but trust me, it was very embarrassing. Anyway, the same with copyrights. Copyrights are public. They're harder to search than trademarks, much harder to search. But if you're copywriting a song, say, that you're going to introduce, but you're not going to publish it for 6 more months, you might not want to file the copyright registration just yet, because somebody could read the lyrics and now they have possibly a right to license it under compulsory licensing laws and sing it before you do. So you don't want to do that. Computer programs, you have to disclose some of the code, not all of it, depending on the situation. But you may not want to do that for a competitive advantage. Patents, patent applications in the US and in most other countries are published 18 months after they're filed. In the US, you can avoid that in some ways. Not necessarily a good idea, but you can.
We've talked about reasons to pursue patents, copyrights, trademarks. Are there any reasons to not pursue them or things to consider before you go about pursuing those types of intellectual property?
Absolutely. We already talked about how when you file a trademark registration, you have to describe the goods you're going to sell. So you're going to tell your competitors and the public what you're going to do, especially if you file an intent to use before you actually start doing it. Copyright and trademark registrations are public, unlike patent applications, which we'll talk about in a second. So 2 weeks after you file that trademark registration, everybody knows that you're going into the tape measure business, soda pop business, whatever, and you may not want your competitors to know that yet, especially if you're an existing company that's diversifying. So that's one reason not to file a trademark. As far as copyrights,
let's go back to the trademarks. I guess if you have some idea, but you're not sure when you're going to use it, and it could be more than 3 years or so, then you may want to hold off.
Absolutely. Because you can, so to speak, hold a trademark with what's called an intent to use application. Normally, you have to be using the mark to file it. But if you do the intent to use, you have up to 3 years, and there are some costs that do add up to keep it for that long. But it can be a really good idea. But those are still public, and you may or may not want to file it until you're ready for the world to know that you're going into this business.
And then you were starting to talk about copyrights when I so rudely interrupted.
It'll be all right. Copyrights, we do have to disclose them. I'll give you 2 quick examples. Number one, suppose you've written a song, but you're not ready to publish it yet or perform it. If you register it with the Copyright Office, it will be available. People could read it. And because music has a compulsory licensing scheme, they could even record and publish it before you do. So you might not want to file it until you've recorded it, you're ready to go. Then as far as the computer programming, which is another huge thing for copyright, you have to disclose some, not necessarily all, of the code in any given computer program to file a copyright registration. You may not want to do that for obvious reasons, because then they can review it. An experienced tech attorney knows how to file these applications to keep commercial disclosure to an absolute minimum. It's not hard to do, but you do have to know what you're doing. I like to say about both the copyright and the trademark registration forms, they're actually very easy to fill out, and they're even easier to fill out wrong. So you really want somebody with experience to look at those. And then, of course, for patents, they're not even easy to fill out the first time. Patent applications, same thing in a way, Patent applications are usually published in the US and other countries 18 months after you file them. So if you're not ready for the world to see your application just yet, and you're not worried about prior disclosure or somebody beating you to market, then you might want to hold off a little bit till you get a factory tooled up or some investments in line, whatever. That's something an experienced business attorney can help you with as well, who kind of knows all the facets of this. But you do want to get that as fast as you can once you decide to go for it, because if anybody else sells it, discloses it, invents it, it could prevent you from getting a patent. And also, you can't sell or disclose it with certain exceptions until you've filed it, or you may endanger your own application.
So then how does trade secrets get into that? I guess if you think if something might be easily reverse engineered, or it's too hard to go after someone, and you may want trade secrets because I guess they could theoretically last forever. Take, for example, the Coca-Cola recipe. What factors, instead of filing for some other type of intellectual property, I guess with trade secrets, you're not filing it, but you do have to do some things. What are some factors to consider in that regard?
Well, trade secret law is heavily developed in the US, but usually at a state level. Most of the big commercial states, New York, California, uh, Illinois, have good trade secret laws. There is a federal trade secret law, but it's very broad and it only touches on a few topics. Again, something that you need some expertise in to know about. Um, Trade secret just means any information that is not known to the general public outside your business that is valuable, that if it were disclosed, it would be less valuable to your business. Classic example, customer list. One of your salespeople quits, takes their customer list with them. I have been involved in very extensive and very expensive litigation over just the salesperson walking out with their customer list. That is highly confidential information and extremely valuable. It could be as far as machine processes. Anything that can be reverse engineered as a machine really should look into a patent. But if it's something that the process is not obvious, even if the result is, you might want to keep it as a trade secret. It's certainly something to talk about with an experienced attorney. And if you want to see the ultimate trade secret, you should look at a book called Friday by Robert Heinlein, where the ultimate trade secret is actually a major part of the plot of the book. But in any event, it's something that certainly is a viable approach to protecting your information and not filing it, because anything you file eventually is going to get disclosed to the public.
What about intellectual property insurance? I know people think about auto insurance, homeowners insurance, uh, all kinds of different insurance, but what about intellectual property insurance?
Well, getting insurance is another thing that either your accountant, your insurance broker, or your attorney will help you with when you start up. But most business general liability insurance, even if it has omissions and errors insurance, doesn't cover intellectual property infringement. It is specifically disclaimed. You have to buy a separate policy. If somebody sues you for patent infringement, if somebody sues you for copyright, trademark infringement, or even for trade secret infringement, if you hire that salesperson and they come in with that Rolodex, you can get sued. But your general liability insurance is not going to cover any of that. Intellectual property insurance can be very expensive. It is related to data breach and privacy breach insurance, which is another thing you should talk about with your broker and your lawyer, which is also very expensive because the potential losses are enormous. On the other hand, the potential losses are enormous, and your insurance company will pay your lawyers for you. So certainly a thing to think about, but be prepared to hear some very big numbers. Otherwise, what you want is to do clearance on what you use, whether it be machines for patents, trademark names, copyrighted materials, and make sure that you're okay to use it. Then you don't need a license and you're not worried about it. That's called a freedom to operate search. And it's another thing that firms like Stein are very good at.
When considering all this, I guess you could go with the saying, anyone can sue anyone at any time over anything. So it depends what your comfort level is, just as in deciding how much auto insurance you have or life insurance.
Exactly. Your job is to be informed of the risks. My job is to inform you of the risks, and then you make a decision as to where you want to put your capital.
With respect to an owner, should the owner take out or pay themselves in wages or just take money out of the business from profits? I would imagine there's a number of factors that go into that.
That is huge for two reasons. Number one, it is often advantageous to take wages to make yourself an actual W-2 employee. Your accountant will know better than I, but because the business is, it's easier for the business to write off certain expenses associated with those payments if you take a certain amount of your pay in wages and then take distributions for other parts if you need to. Obviously, if you just take distributions, you don't have to pay quarterly taxes on that, although then you have to pay your taxes at the end of the year. So you will eventually pay your taxes. But again, a tax accountant can help you more with that. It's certainly something to keep in mind. Don't just assume one way or the other. There is a difference. The second thing is if there's more than one person involved and people are taking money out, making themselves loans, quote unquote, or otherwise moving money in and around or buying things, that can turn into arguments very quickly. So you really want to have it clear who's getting paid to do what, and if distributions are to be made, how they are to be made, how they are to be balanced. That's all goes into your operating agreements and so forth when you form your entity, but it's really, really important. And it probably is the number one or number two cause of startup companies breaking up internally as opposed to just, externally not making the market. Because once money is involved, as I noted before, relationships can tend to degrade very quickly.
As far as home office, flex office, uh, getting a separate office, virtual, are there any things to consider in that regard?
Obviously, you have to have an office big enough to do whatever physically it is you do. If you're going to manufacture, you got to have a manufacturing. If you're going to store things, you got to have a warehouse, et cetera. Keeping the business in your office, especially if it's heavily IP centric, it's a business that doesn't have a lot of physical property, can make a lot of sense. It's harder than it used to be to write off space in your home for taxes, but it's certainly doable. Again, that's more of an accountant question. But having a physical office, at least a flex office, if not an actual physical small office that you rent, can be really advantageous because states and vendors and other people that you interact with want to know where you are. Customers will Google your address, and if your address comes up as a nice house in the suburbs, but you're trying to sell them $1 million software package, they may be a little hesitant. So you might want to think about that as well. That's more a business decision.
Good point. Yeah.
But as far wherever you put that office, you are subject to the municipality, the county, the state, and the country where the physical office is, and that can be a big deal, especially if you live near a border and you have people commuting. I live in Illinois. A lot of people in Chicago commute to Indiana. There are actual treaties between the states of Illinois and Indiana and Illinois and Wisconsin regarding who gets whose income taxes, depending on where they live. So having an office does subject you to the jurisdiction of more entities. So that is one reason you might not want to do it. But generally speaking, it's a good idea to at least have a flex office and a business location for marketing purposes, because you don't want people to be looking at your house or looking at the UPS store, if you rented a drop box. So it's something to keep in mind.
And then last question, because we've covered so much already, is what kind of paperwork does a business owner need if he's going into a business with a friend or a close contact?
Yes, again, huge thing, causes a lot of stress. Again, we're like plumbers. Call us before the leak gets bad. And the leak is your friendship or your familial relationship. Typically, that's all incorporated into the operating agreement of an LLC or the articles of incorporation and operating agreement of a corporation. Sometimes people will also contract, especially if you have a partnership. And by the way, if you go into business with your friend and you don't form a corporate entity, guess what? The state will form one for you. The second you start transacting business with them, the state considers that to be a general partnership, which is the absolute worst form of corporate entity for anyone. That's a more general question. But certainly, if you're going to do business with somebody, there needs to be paperwork, because otherwise the state will write it for you, and you don't want that. But you need a contract, because we're friends. It'll be all a handshake. I've known him for years. I could not tell you how many friends and relatives I've seen who don't talk to each other
Yeah,
ever again.
getting to your point, was
So,
handling, or I was involved in a matter where two brothers, they were in business 35 years. One really owned the business, the other one was really an employee, but he didn't view himself that way, and it got into the "you promised this," "oh, I didn't promise, I never said that" kind of thing. So I totally get your point in that regard.
yeah, so you need a paperwork, that's going to be part of your picture. You're going to come in and say, I'm going to be the person who's making the phone calls. He's going to be the person who's writing the code. Whatever the division is, you spell it out. There's an old saying in the law that I invented: when in doubt, spell it out. So we put that in your agreements, or we have a separate agreement, especially if anybody is going to be contributing money as capital, because there needs to usually be a loan agreement or some kind of equity agreement. And it's all things that we can help you with easily. We do it every day, but it's things that you're trying to get your business rolling. You don't need to be thinking about this. And if you try to learn it yourself, that's just that much less effort and energy to devote to the business. So really, have one of us help you. It's what we're here for, and we will save you a lot of heartache, let alone money down the road.
Well, thank you, Mark. I know there's plenty of other issues that we haven't even had time. Maybe we'll have another podcast on that. And to all you viewers out there, thank you for tuning in, and hope to see you next time on Unraveling Intellectual Property with Michael Stein. Take care.